Justice Albie Sachs aptly captured this essence in the case of August and Another versus the Electoral Commission and Others, South African case, where he said, universal adult suffrage on a common voter's roll is one of the foundational values of our entire constitutional order. The achievement of the franchise has historically been important both for the acquisition of rights of full and effective citizens by all South Africans, in this case, read Kenyans, regardless of race, and for the accomplishment of an all-embracing nationhood. The universality of the franchise is important, not only for nationhood, but also for democracy. The vote of each and every citizen is a badge of dignity and of personhood. Quite literally, it says that everyone counts. The interpretation, that's end of quote from Albie Sachs. The interpretation and application of the Bill of Rights must not be mechanical or limited to a court's interpretation of legislation. To favor legislation over the Constitution would be an affront to the supremacy of the Constitution. The exercise of the sovereign power of the people in relation to the political processes of the state is first to be found in Article 1, which provides that all sovereign power belongs to the people of Kenya, who exercise their power directly or through their elected representatives, and also delegate it to the three arms of government at both county and national level. The second reference to this sovereign power of the people is to be found in the Bill of Rights under Article 38. Under Article 38, 2 and 3, where it says, every citizen has the right to free, fair, and regular elections based on universal suffrage and the free expression of the will of the electors, and every adult citizen has the right to be registered as a voter, to vote by secret ballot in any election or referendum, and to be a candidate. There cannot be any doubt at all that in interpreting and applying any provision of this Constitution, the Elections Act and the regulations thereunder, this court must adopt an interpretation that promotes the Grundnorm in Article 1 and the right to vote in Article 38. Articles 81 and 86 of the Constitution reinforce the right to vote, elaborated under Article 38 of the Constitution. These constitutional provisions or principles must therefore be applied to this core right in Article 38 and not vice versa. Articles 81 and 86 are to be facilitative of the fundamental rights under Article 38, in addition to other provisions of the Constitution. In fact, there are many other articles of the Constitution, legislation, and regulations whose purpose is intended to give effect to, facilitate, and support the right to vote under Article 38. In the application and implementation of all those provisions, the centrality of Article 38 as the primary purpose for their existence must never be lost. This was the position elaborated in the case of Evans Kidero versus Ferdinand Waitito, where this court held at paragraphs 137 and 138. Quote, Chapter 7 of the Constitution is entitled Representation of the People and bears the subtitle Electoral System and Process, with further subtitle General Principles of the Electoral System. Articles 81, 82, 83, 84, 85, 86, and 87 all fall under this chapter. It is plain to us that most of the provisions in these articles are rendered in the form of principles, some general, others not so general. And thus expressed, it is unavoidable that most of these principles are not self-executing, which fact moves the judicial forum to center stage as regards interpretation and application. These principles cannot crystallize into deliverables of public goods, such as those in the nature of governance and elections, without further legislative action. Thus, Article 82 provides that Parliament shall enact legislation to provide for the conduct of elections. A reading of the majority decision also appears to presume that the only test for ascertaining the credibility of the election process, or more correctly, for assessing any violation of the rights under Article 38, lie in Articles 81 and 86. This is not the case. Articles 82 and 83 also go to the specifics of the electoral process that support the right under Article 38. Article 82 and Article 83 address the registration of voters and underline the requirements of the voting exercise itself as simple, accurate, and taking into account those with special needs. Article 83(3) states clearly, quote, administrative arrangements for the registration of voters and the conduct of elections shall be designed to facilitate and shall not deny an eligible citizen the right to vote or stand for election. The upshot being that the tests for assessing a violation claim under Article 38 must be more comprehensive than the aspirational guidelines set out under Articles 81 and 86. Cherry-picking constitutional provisions to determine a right-centric cause on the basis of formal considerations, which is the choice of form over rights, undermines a purposive approach to the interpretation and application of the Constitution. The Constitution, in Article 259(1), also clearly sets out the framework for applicable principles while interpreting the Constitution, and this article provides that this Constitution shall be interpreted in a manner that advances the rule of law and the human rights and the fundamental freedoms in the Bill of Rights. Further, the Constitution under Article 23 states, in applying a provision of the Bill of Rights, the court shall develop the law to the extent that it does not give effect to a right or fundamental freedom and adopt the interpretation that most favors the enforcement of a right or fundamental freedom. In my humble opinion, the majority has not given effect to the people's right to franchise and have not interpreted broadly and in a manner that most favors its enforcement. The case for the advancement of the Bill of Rights clearly must therefore be at the forefront of any judicial determination under the Constitution of Kenya. There is a more complex issue that must be addressed. Article 19 of the Bill of Rights states as follows: the Bill of Rights is an integral part of Kenya's democratic state and is the framework for social, economic, and cultural practices. The purpose for recognizing and protecting human rights and fundamental freedoms is to preserve the dignity of individuals and communities and to promote social justice and the realization of the potential of all human beings. The rights and fundamental freedoms in the Bill of Rights, A, belong to each individual and are not granted by the state. B, do not exclude other rights and fundamental freedoms not in the Bill of Rights. And C, are subject only to the limitations contemplated in this Constitution. If the rights under Article 38 may not be limited other than by a specific provision of the Constitution, can an interpretation of Articles 81 and 86 purport to take the essence of those rights away from any Kenyan? Where a voter has made his choice known, having been registered in accordance with Articles 82 and 83 and 138(3) of the Constitution, Having voted in accordance with Articles 81 and 83, and his vote counted at the polling station under Article 138(3)(c), and the result announced at the polling station in accordance with the Constitution and the law, and that outcome is known and uncontested, then can a general principle, non-specific to any precise act, overturn that choice and undermine a fundamental right? Can an operational aspect of an election, such as Article 81, cancel a result or outcome as provided under Article 38 that is unchallenged? And further, where in fact the election is not challenged as to the aspect that the result or outcome has been violated, can a claim that does not plead violation of a fundamental right extinguish the enjoyment or exercise of that right? Can it be argued that there are two competing provisions of the Constitution, one provision guaranteeing the right and the other burdening the enjoyment of that right? And if this is the case, how would one balance to ensure an outcome that does not upset the will of the people? We can draw lessons from the observations of Professor Rex Martin on his exposition of John Rawls' theory of justice in his book Rawls and Rights, where he states, quote, "The weight of a right is a determination, sometimes explicit and sometimes not, sometimes quite exact and sometimes rather imprecise, of how it stands with respect to other normative considerations and whether it would give way to them or they to it in cases of conflict." Similarly, a scholar, Noor Kayan, in her paper, How to Resolve Conflicts Between Fundamental Constitutional Rights, puts across an interesting point, which I fully agree with, that, quote, "The discretion that the judges enjoy when applying the balancing method is part of their duty as guardians of the law. One general rule which embraces all situations in which a conflict occurs and gives a common technique to resolve them all cannot possibly be formulated. Even if a single solution was to be formulated, it would not serve justice in each situation, since every case has its own specific circumstances. Also, the discretion of judges is not without any limits. They have to follow the principle of proportionality. The answer to the question, how to resolve conflicts between fundamental constitutional rights, is, at the end, quite simple: balancing. Thus, even though there may appear to be a perception that a competing rights situation exists, that is between Article 38 and 81 and 86, there must be a balancing and an application of proportionality to effect a judicial outcome that serves the dictates of the Constitution. One must recognize that not all claims will be equal before the law. Some claims have been afforded a higher legal status and greater protection than others. While there are many situations in which rights, principles, and values may seem to conflict or compete, when evaluating situations of competing rights, human rights, particularly those provided in a Bill of Rights, will usually hold a higher status than principles and values. This rationale is further underlined by the architecture of our Constitution, which actually ring-fences the Bill of Rights from amendment, which may only be made through referendum by the people of Kenya, unlike the principles in Article 81 and 86, which may be amended by elected leaders in Parliament. This plebiscite protection in itself places the Bill of Rights higher in the pecking order of competing provisions in the Constitution. The principle, therefore, should complement the right and not vice versa. The principles in Article 81 and 86 therefore cannot trump the fundamental rights as provided for under Article 38. And certainly, they cannot undermine the provisions of Article 1 on the sovereignty of the people. Further, they ought not compete with all international treaties that provide and protect the right to vote, and to which Kenya is a signatory and which are part and parcel of our constitutional order under Article 2. We can go further to draw from decisions of the Indian Supreme Court as relates the conflict between fundamental freedoms and the directive principles in the Indian Constitution. Harmony between aspiration, reinforcing or guiding provisions and rights is, however, critical. In India, the Constitution provides for both fundamental rights and directive principles. The Indian Supreme Court has, in a number of judgments, called these principles the conscience of the Constitution, and also as the core of the Constitution. That court has held that the courts can look to the directive principles for the purposes of interpretation of a fundamental right and adopt that interpretation which makes the fundamental right meaningful and efficacious. But more importantly, the Indian Supreme Court has pronounced itself on instances where there is a conflict between the fundamental rights and the directive principle. And it has held in a number of cases, which I have quoted, I'll not go into, that the chapter on fundamental rights in the Constitution is sacrosanct. And the directive principles have to conform to and run subsidiary to the chapter on fundamental rights. The conclusion may therefore be drawn that fundamental rights constitute the foundation of any constitution, and any accompanying values and principles are to be complementary and not to detract from the Constitution. The rights in Article 38 remain central to any election cause, and it is claim of the violations of those rights under Article 38 that ought to take center stage in such a cause, and not the form that accompanies it in the periphery. Having determined, therefore, that election causes are rights-centric in nature, and having discussed the centrality of the citizens' rights to a free, fair, regular election based on universal suffrage, and the free expression of the will of electors for any public body or office established under the Constitution, I am now going to evaluate the alleged violation of Articles 81 and 86 of the Constitution of Kenya and its effect upon the outcome of the presidential election that is in dispute before us. Now, the case of the petitioners is that they were massive, systematic, systemic, and deliberate non-compliance with the Constitution and the law, which contravened the principles of a free and fair election under Article 81E, as read together with Sections 39, 44, and 44A of the Elections Act and the regulations thereunder. The petitioners assert that the relay and transmission of results from the polling station to the constituency and the National Tallying Center was not simple, accurate, verifiable, secure, accountable, transparent, and prompt, contrary to the provisions of Article 86. The petition elaborated that the non-compliance was on the Form 34's A's and B's, which is that the data and information recorded in Form 34A at individual polling stations were not accurately and transparently entered into the KIMS kits. B, that the data entered into the KIMS kits ought to have been accompanied by an electronic picture or image in the prescribed Form 34A. C, that the practice manual verbally communicated and publicly demonstrated by the first respondent to the parties and stakeholders demonstrated that the transmission of any data from the KIMS kit was only possible if the data was simultaneously accompanied by the image of the Form 34A. D, that the results from over 10,000 polling stations were not accompanied by an electronic image of Form 34A. E, that the data being being publicly displayed by the first respondent was not consistent with the information on Form 34's A. F, that the first respondent received in excess of 14,000 defective returns from polling stations affecting over 7 million votes. G, the information on Form 34B did not correspond with that in the primary Form 34A, making them inaccurate, unverifiable, and invalid. H, that the inconsistencies in Forms 34B accounted for at least 7 million votes. I, at the time of declaring the results, the first respondent did not have 187 Forms 34B. J, the computation and tabulation of results in a significant number of Forms 34B was not accurate, verifiable, and internally consistent. K, the purported results in the first respondent's Form 34B were materially different from what the first respondent publicly relayed and continued to relay as at the time of filing in its website or portal. L, that the results in Form 34B were inaccurate and had mathematical additions in favor of the third respondent. M, that some of the returns in a material number of polling stations were not in prescribed Form A or Forms 34A or 34B, contrary to the regulations. N, that Forms 34N bore fatal irregularities affecting 14,078 polling stations. O, that a number of forms and returns were not signed. Some forms did not indicate the names of the returning officer. Some did not bear the IEBC stamp. Some Forms 34A and 34B did not bear the signatures of the candidate's agents, nor the reason for refusing to sign. Some were signed by the same person presiding in different polling stations. And P, in more than half the constituencies, the returning officers failed to indicate the number of Form 34As handed to them as required under the laws and regulations. As such, it is alleged it was impossible to authenticate and verify the results given as the integrity of the forms had been put into question and the forms were unknown to the law. There's also allegations of fraud on the part of the first respondent, that the accusation is that the first respondent selectively manipulated, engineered, distorted the votes cast, and counted in favor and inflated those in favor of the third respondent, thereby affecting the final results tallied, that the presidential election was marred and compromised by intimidation, improper influence, or corruption, and that the third respondent with impunity contravened the rule of law through the use of intimidation, coercion, and public officers. There is also allegations of vote counting, that a number of votes in significant number of polling stations were not counted, tabulated, and collected in accordance with Article 86B and C. There is also complaints about the transmission process, stating that the respondents' process of relaying transmission votes from the polling stations to the constituency tallying centers and the National Tallying Center was not simple, accurate, verifiable, secure, accountable, and transparent, and prompt. That the IEBC deliberately or negligently compromised the security of the KIMs and therefore exposed it to unlawful interference by third parties. The evidence was presented through 12 dispositions, affidavits sworn by Raila Odinga, Stephen Kalonzo Musyoka, Dr. Nyangasi Oduor, George Kigoro, Benson Wesonga, Godfrey Osotsi, Ibrahim Mohamud, Mohamed Nur Bar, Moses Wamuru, Olga Karani, Apriel Oichoi, and Koitemet Olakina. This evidence, together with a complete record of the responses, again is contained in the dissenting opinion of Justice Ojwang. I will not repeat it. I just go straight to the analysis. The pertinent issues for consideration in this regard, in light of the pleadings, the evidence and submissions, ought to evaluate the provisions of Article 81 and 86 of the Constitution in the broad scheme of electoral prerequisites mandated by the Constitution. Article 81 outlines the general principles of the electoral system. Kenya's electoral system is instituted on the basis of a multi-party democracy founded on the national values and principles outlined in Article 10 of the Constitution. Most importantly, the Constitution provides a formula for the election of the president. More than half of all the votes cast and at least 25% of votes cast in each of more than half the counties. For the other 5 elective posts in a general election, the applicable system is first past the post. The person with the most number of votes is the one to be declared the winner. The electoral system and process is therefore discernible from a holistic reading of the Constitution, particularly Chapter 7, the representation of the people, 8, the legislature, 9, the executive. The general principles under Article 81, which in my view are qualitative, are infused in the entire fabric of these chapters, and their resultant legislation are concretized by other provisions of the Constitution, including Article 38, Articles 10, 27, 38, 56, 82, 90, 91, 100, 54, 56, 82. There's universal suffrage under 38 again, secret ballot under 38. This collectivity and interlocking nature of constitutional provisions in the scheme of rights, values, principles, and administrative directives are then infused in the Elections Act and regulations. And therefore, in determining the claims of commission or omission in electoral disputes, a court must consider the following things. A, the nature of the commission or omission in general. B, the source of such omission or commission. C, foreseeability and mitigation. For example, could the commission or omission be foretold? And were there steps taken to avert it? D, the effect of the commission or omission on a right, a duty, or the consequence of the duty thereof, such as effect upon the result of an election. E, the effect of the commission or omission on the individual and the collective. And finally, the court ought to look at possible remedies and directions. The rationale of these considerations may be drawn from the case of Mike Wanjohi, where at paragraph 110, this court stated, by the design of the general principles of the electoral system and of voting in Articles 81 and 86 of the Constitution, it is envisaged no electoral malpractice or impropriety will occur that impairs the conduct of elections. That is the basis for the public expectation that elections are valid until the contrary is shown through a recognized legal mechanism founded in the law or the Constitution. Any contest as to the credibility, fairness, or integrity of elections belongs to the courts. The charge of commission of administrative error, fraud, deliberate misconduct, or element of corrupt practices are questions that go to the root of the validity of the elections, and which, if apparent subsequent to the declaration of results, are expressly excluded from the scope of the dispute resolution of the IEBC. So 81 is qualitative. Article 86, on the other hand, bears a strict quantitative language regulating voting at an election. This article requires that the voting method be simple, accurate, verifiable, secure, accountable, and transparent. The petitioner's claim is that the results from the polling stations right up to the National Center could not be verified by their agents. The process of verification is not a two-step process. Verification in a presidential election is a continuous process traceable from the date of registration to voters to the determination of the presidential election petition in an election court. In other words, the plurality of persons engaged in a conduct of elections, including the ultimate determination of the election's validity, are all agents of verification in ascertaining the credibility of an election. To examine the integrity of an election, the election court is obliged to consider all the relevant steps of the verification process. And we shall examine the role of each one of them. First, let us go to the agents of verification. First, there is the IEBC. This IEBC, established under Article 88 of the Constitution, is mandated to conduct and supervise elections, and they have other duties and obligations such as continuous registration of voters, the revision of the voters' roll, facilitation and observation and monitoring and evaluation of elections. And the Independent Electoral Boundaries Act also outlines the powers and functions of the Commission. The second agent of verification is the public. Section 6 of the Elections Act mandates the Commission to avail the register of voters to be inspected by the public at all times for the purposes of rectifying particulars. So verification of one's registration details, including biometric data, is therefore a critical part of verification, essential to the conduct of the election and enjoyment of the right to vote. This assures the public of the correctness of registration details entered into the register and guarantees key components of the right to vote under Article 38. I note that this process was undertaken in the months of May and June this year. Another agent, verifying agent, are the candidates and their agents. So, the Elections Act empowers a political party, a nominated agent, an independent candidate, to nominate their agents per polling station. And these agents are the eyes of the candidates, and they verify at every stage where they are to be found. Another agent is the political party in itself. So you have first the candidate, then the agents, and then the political party. Another agent is the constituency returning officers, who, for the purposes of this election, collated and announced the results from the polling stations and submitted the collated results to the National Tallying Center. They're also the presiding officers. They're also verification agents. They are the ones who ensure the voting is done properly, that the stations are closed on time, that the counting is done properly, and that all the results are properly recorded. Another agent of verification are representatives of the electronic and print media. And this is provided for under the regulations. So they actually have a regulatory role as agents of verification. Then there are the observers, the local and international observers, who are also accredited by the Commission and who, under the Elections Act, Regulation 94(6), are required to submit their official reports to the Commission. And therefore, the reports so filed have a formal and official status. They are not to be casually looked at. All the international observers who observe the general elections termed it as fair and free. That is in the reports that they filed. And there are fundamental questions to be considered. What was the input of their reports with regard to the fairness of the elections? What is a free and fair election? What did the election observers consider? International election observers are bound by the Declaration of Principles for International Election Observation, an international instrument, which says, quote, "The systematic and comprehensive and accurate gathering of information concerning the laws, processes, and institutions related to the conduct of elections and other factors concerning the overall electoral environment, the impartial and professional analysis of such information, and the drawing of conclusions about the character of electoral processes based on the highest standards for accuracy, information, and impartiality of analysis. International election observation should, when possible, offer recommendations for improving the integrity and effectiveness of electoral and related processes while not interfering and thus hindering such processes. International election observer missions are organized efforts of intergovernmental and international non-governmental organizations and associations to conduct international election observations. Despite not having a universally acceptable definition of a free and fair election, there are certain common attributes to that description. They were aptly expressed by the Constitutional Court of South Africa in the case of Kham and others versus the Electoral Commission and another as follows, quote, "There is no internationally accepted definition of the term free and fair elections. Whether any election can be so characterized must always be assessed in context. Ultimately, it involves a value judgment. The following elements can be distilled as being of fundamental importance to the conduct of free and fair elections. First, every person who is entitled to vote should, if possible, be registered to do so. Second, no one who is not entitled to vote should be permitted to do so. Third, insofar as the elections have a territorial component, as is the case with municipal elections where candidates are in the first instance elected to represent particular wards, the registration of voters must be undertaken in such a way as to ensure that only the voters in that particular area are registered and permitted to vote. Fourth, the Constitution protects not only the act of voting and the outcome of elections, but the right to participate in elections as a candidate and to seek public office," end quote. I've also laid out another case in which the discussion of what is free and fair and what are the standards of fair election are set out, and that is in the New National Party of South Africa versus the Government of the Republic of South Africa and others. Finally, as a verification agent is the election court. Let me reiterate, Kenya's electoral system is instituted on the basis of multi-party democracy, founded on national values and principles outlined under Articles 10 of the Constitution. The general principles of the electoral system, therefore, and the interlocking constitutional provisions, including Article 81, are engaged in an exercise of sovereign guardianship. Therefore, the Supreme Court, by dint of its jurisdiction, is the final verifying agency, if called upon to do so in a presidential election petition. This duty is enabled by the Supreme Court's inherent powers as an election court to order A, scrutiny, B, recount, C, retally, D, discovery of documents, E, inspection of ballots, and F, orders that facilitate the court to establish the people's sovereign will. The Supreme Court, as an election court, is empowered by Article 138(3)(c), Articles 140 and 163(3), and also under Sections 2, 80, 82, 85 of the Elections Act. It is critical to meet the constitutional imperative set upon the court and the electoral body by the Constitution. An election court must make sure there is a solid, not imagined, proved, not alleged, case for invalidating an election. The South African Constitutional Court in Kham and others remarked, and I'm fully persuaded by the opinion as follows: "It is undesirable to articulate a general test expressed in language different from that in the Constitution, as that may be misleading. The court must give full weight to the constitutional commitment to free and fair elections and the safeguard it provides to the right and ability of all who wish to offer themselves for election to public office, it is essential to hold the IEC to the high standards that its constitutional duties impose upon it. It is insufficient for the court to say that it has a doubt or a feeling of disquiet or it is uncomfortable about the freedom or fairness of the election. No. The court must be satisfied on all the evidence placed before it that there are real and not speculative or imaginary grounds for concluding that the election was not free or fair. Now, having talked about who the agents of verification are, then let's discuss, or let me talk about what are the stages of the process of verification. Regulation 68 provides that ballot papers shall contain the name and symbol of the candidate validly elected, contain the photograph of the candidate where applicable, be capable of being folded up, have a serial number or combination of letter and number printed on the front, and have attached a counterfoil with the same number combination printed thereon. These features allow candidates or agents present at the polling station to inspect and verify the ballot paper that is going to be used at the polling station. Then Regulation 69 outlines the voting procedure, which contains the core components of verification, which are complemented by the requirements of inspection and verification of the voter's register. And it says, before issuing a ballot paper to a voter, an election official shall, A, require the voter to produce an identification document, which shall be the same document to be used at the time of registration as a voter. B, ascertain that the voter has not voted in that election. C, call out the number and name of the voter as stated in the polling station register. D, require that the voter place his or her fingers on the fingerprint scanner, cross out of the voter from the printed copy register once the image has been retrieved, and in case the electronic voter identification device fails to identify the voter, the presiding officer shall invite all the agents and candidates in the station to witness that the voter cannot be identified, to complete the verification form 32A in the presence of the agents and candidates, identify the voter, and once identified, issue the voter with the ballot papers. A voter shall in a multiple election be issued with the ballot papers for all the elections therein at the same time, and after receiving the ballot papers, cast his vote without undue delay and submit one finger to be dipped or marked in an ink of distinctive color, so far as possible, is sufficiently indelible to leave a mark for the period of election, and where the voter has no finger, make a mark on the next most suitable part of the body. And upon collecting his identification documents, immediately leave the polling station. A person who knowingly fails to place a ballot paper issued with him or her, not being a spoiled ballot paper, into a ballot box before leaving the place where the box is situated, commits an offense. An election officer who deliberately refuses to stamp any ballot paper commits an offense. The presiding officer may, where the voter so requests, explain the voting procedure to such a voter. Then at the close of the polling, the presiding officer is supposed to indicate in the polling diary the numbers of the ballot papers issued to him, the number of the ballot papers other than the spoiled ballot papers issued to voters, the number of the spoiled ballot papers, the number of the ballot papers remaining unused, all in the presence of the candidate or agents, and seal and put in tamper-proof envelopes those unused ballot papers before they proceed to count, and then seal those boxes with the ballots that have been counted. The preservation of election material for a period of 3 years is also an enabler of the verification process. In cases where a court is in grave doubt as to the outcome of an election, as the majority in this case decided they were, the ballots exist to enable a final inspection or verification process by the court. The people speak through the ballot, and the ballots once marked, cast in turn, speak for themselves, anonymous of the voter, preserving the principle of secrecy under Article 38. India's long constitutional tradition has given the Supreme Court an opportunity to rein in on the importance of ballots in verifying of the result of an election when in doubt. They have said this, I quote, this is in the case of Narendra Madhivalappa, Kenny versus Manikarao Patel and others. Quote, the ballots are alive and available and speak best. Why then hazard a verdict on flimsy grounds of oral evidence rendered by interested parties? The vanquished candidates' ipse dixit, or the victor's vague expectations of voters' loyalty, the grounds relied on, are shifting stands to build a firm finding upon, knowing how notorious is the cute art of double-crossing and defection in electoral politics, and how undependable the testimonial lips of partisans can be unless authenticated by surer corroboration. Chancy credulity must be tempered by critical appraisal, especially when the return by the electoral process is to be overturned by unsafe forensic guesses. And where the ground for recount has been fairly laid by testimony, and the ballot papers which bear clinching proof on their bosoms are at hand, they are the best evidence to be looked into. No party can run away from the indelible truth, and we wonder why the learned judge avoided the obvious and resorted to the risky. Maybe he thought reopening and recount of ballots may undo the secrecy of the poll. We are sure that the correct course in the circumstances of this case is to send for and scrutinize the ballots for the limited purpose of discovering who